So the question is, may AI output be original at all, or whether an AI output is always a non-original object generated by a computer program? The practical and doctrinal answers to this question are controversial. The first approach says no. Since only the form of expression is protected, and not ideas, it doesn't matter how creative the prompt is. AI itself will draft the output and produce the final form of expression. And that's why an AI output can never be original. Although humans can set parameters to guide AI outputs, the matter is that not only the link between the human's creativity and the resulting object is weakened or even broken, but what is more important, the fixation of an output in a tangible minimum for expression will be made by the AI system itself, not by a programmer or user. And since only the form of expression is protected, and since this form of expression is fixed by AI, then it doesn't matter how creative the prompt is. An AI output can never be original and copyrightable. Along with that, there is the other approach, and this approach says yes. An AI output can be original and copyrightable. If creative choices are expressed in the output, then it is original. While AI can play a crucial role in producing a draft of an object, in many cases designing the object and the reduction phase require creative choices by a human, and if these choices are expressed in the output, then it is original and copyrightable. For example, in the case Shenzhen Tencent versus Shanghai Yuxun, the court found efforts in the designing phase enough in order to consider the output original. The second approach seems more reasonable. If a prompt provides a detailed understanding of the future expression, and if the output represents the instructions, then the link among the overall intent, instructions, and expression is kept, and the user can be considered an author. Even if prompts are too broad, the lack of originality in the designing phase may still be compensated in the reduction phase. Further, practice knows other examples than related to AI where human creativity during the drafting state is limited, but we still consider the outputs original. Imagine that you are taking a photo. Taking a photo itself requires one button click. However, the preparation state is crucial, and if your choices made during the preparation stage are reflected in the photo, if these choices are free and creative, then the photo is considered original, and then it is copyrightable. Another example is represented by the research article authorship standards established by the recommendations for the conduct, reporting, editing, and publication of scholarly work in medical journals. These recommendations establish that in order to be considered a co-author, a person should substantially contribute to the conception or design of the work, or the acquisition, analysis, or interpretation of data for the work, and draft the work or review it critically for important intellectual content, and make a final approval of the version to be published, and agree to be accountable for all aspects of the work in ensuring that questions relating to the accuracy or integrity of any part of the work are appropriately investigated and resolved. It means that a person who substantially contributes to the conception or design of the work, who reviews it critically, who makes a final approval of the version to be published, and who agrees to be accountable for all aspects of the work is considered an author, even without participation in the drafting state. Drawing an analogy, we can conclude that a person who substantially contributes to the conception or design of the work by prompt submission, who reviews it critically by evaluating the obtained outputs and submission of additional prompts if needed, who makes the final approval of the work by the final evaluation of the outputs and making the final selection, and who agrees to be accountable for all aspects of the work can be considered also, even without participation in the drafting state at all. It is remarkable that above-mentioned recommendations contain provisions about using AI for research purposes. These recommendations require transparency. Authors who use such technologies should describe this in both the cover letter and the appropriate section. In the acknowledgement section, if AI was used for writing assistance, or in the message section, if AI was used for data collection, analysis, or figure generation. However, in any case, authors should not list AI and AI-assisted technologies as an author or co-author, nor cite AI as an author. Turning back to the question of whether an AI output can be original at all, the answer is yes. Though some outputs cannot meet originality standard and should be considered non-original computer-generated objects, it is still possible to invest creativity and to create a work using AI technologies. This table illustrates prompts and outputs. In the first case, the prompt is represented by a single word, kitten, and you can see the output. Of course, by such a general prompt, a user didn't invest any creativity, and the output cannot be considered original and copyrightable. However, we can deal with more detailed prompts, like in this case. A white kitten with blue eyes, the kitten is looking forward, the kitten is laying on a green blanket, the image should contain the kitten's hat and two paws, background white, style photorealistic, and you can see the output. Also, we can enhance the quality of the output, and you can see the result on this slide. In this case, a user submitted a very detailed prompt, and if the output represents the user's intention, then the output can be considered original and the user can be considered an author. In other words, the more freedom of a human we have, the less freedom of AI we have, and vice versa. If we are talking about a detailed prompt, then the freedom of a human is broad, and the freedom of AI is limited, because AI will just follow the instructions provided by a user. However, if a prompt is broad and general, the freedom of a human is limited, and the freedom of AI is broad, because if AI does not have clear instructions, it will have more options to fill the gaps in the user's prompt. Let's turn back to slides illustrating originality standard. This slide shows how the same idea, sunset over the sea, can be expressed in different ways. And as I have mentioned before, this list can never be exhausted, and an author is always free in his choices and his decisions. And taking this freedom into account and bearing also in mind that there are unlimited number of options of how to express this idea, we can conclude that the output is original and copyrightable. However, there are cases when the creator is under the pressure of different factors, like in case of the classes timetable creation. In this case, a person should take into account students' workload, lecturers' workload, the room's availability, and should understand that a classes timetable which is good should be without windows, and all these factors put pressure on the creator. And the creator is not free in his choices and his decisions, and there is limitation. If we ask ourselves how many options do we have to create a really good classes timetable, actually a few. And taking this limitation into account, we can conclude that a classes timetable cannot be considered original and copyrightable. The same rules are important when we are talking about AI technologies. In this case, the prompt was represented by a single word, kitten, and you can see different outputs. To be honest, kittens look similar, but probably this is because I used the same AI platform. However, the images themselves are different. You can see different backgrounds. Sometimes you can see the whole kitten, sometimes you can see just the hat and two paws. Sometimes the kitten is looking at you, sometimes the kitten is looking at another point, etc. And if you ask yourself, how many options do we have to express the idea of a kitten. Of course, unlimited number of options. But what will be the power who will decide what option to choose and how an output will look like? This will not be a user, this will be AI system itself. In other words, an output will depend on AI system's choices. However, the choices of AI can never be creative, simply because only human can make creative decisions. Therefore, the outputs here are results of non-creative choices made by AI. And since the choices are non-creative, then the outputs are not original and not copyrightable. However, as I have mentioned before, we can deal with more detailed prompts, like in this case. A white kitten with blue eyes, the kitten is looking forward, the kitten is laying on a green blanket, the image should contain the kitten's head and two paws, background white, style photorealistic, and you can see the outputs. In this case, by submission such a detailed prompt, a user did not transfer his freedom to AI. And if we ask ourselves how many options do we have to express and to draw such a kitten? Actually, a few. And the slide evidences this, because all of the outputs look very, very similar. In each case, you can see a white kitten with blue eyes. In each case, we have a green blanket, a white background, photorealistic style, etc. In other words, a user, by submission of a detailed prompt, did not transfer his freedom to AI. And if one of the outputs represents the user's intention from the very beginning, then the output can be considered a result of user's free and creative choices, choices made during writing the prompt. And therefore, such an output can be considered original and copyrightable. Let's look at other examples related to text generators. In this case, I asked ChatGPT to write a short poem, 4 lines, about love. ChatGPT wrote, "Love is a flame that never fades, a widespread breeze, so autumn shades. It binds the soul with threads so fine, and in its light the stars align." Of course, by submission of such a general prompt, I didn't invest any creativity. This is just a very general idea of what kind of an output I would like to obtain. And of course, ideas are not protected by copyright law. And of course, there are unlimited number of options of how this idea can be expressed. And the decision, the output here, dependent on choices made by ChatGPT. But such choices can never be considered creative. And since this non-creativity, the output is not original. And this is a non-original, computer-generated object. However, a text generator can be used as just a writing assistant. For example, in this case, I asked ChatGPT to make the text smoother. And what is important, I provided ChatGPT with the text. The spring air touched her face pleasantly, the girl dreamily cluttered a basket with a violet, the only proof that everything that had happened was not a dream. ChatGPT wrote, "The spring air softly brushed her face as she held a basket with a violet, the only reminder that what had happened was not just a dream." In this case, I provided ChatGPT with the text written by me. And if the output represents my intention, then the output can be considered original. To sum up, an AI output can be related either to works created using computer technologies or to non-original objects generated by a computer program. And the criterion for such a division is originality. However, the matter is that originality is not measurable. Let's compare two situations. In the first case, the person submits data. Then the person chooses a work among many obtained. Then the person creatively edits the work. Of course, in this case, there are options to invest creativity and to have a work created with using computer technologies. However, a person may just click one or several buttons. In the second case, a person clicks one button, so-called generate button. Of course, this is not the case of originality and creativity. But the matter is that between these two polar situations, there are lots of variations. And only case-by-case study can be helpful in treating a particular object and making a decision whether this object is a work created using computer technologies and thus protected under general copyright law regime, or whether this is a non-original computer-generated object which is protected in Ukraine with sui generis rights. Turning back to the question of how to interpret the words combination without juror participation, which is related to one of the attributions of non-original computer-generated objects, the answer is the following. Human participation can be divided into direct and indirect. Direct participation means participation involving creative decisions, and as a result of such participation, we'll have works created with using computer technologies. Indirect participation without direct participation means without creative decisions expressed in the output, and as a result we'll have a non-original object generated by a computer program. From the perspective of copyright law, all the objects can be divided into works created with or without computer technologies which are protected under general rules, and non-original objects generated by a computer program which are protected with sui generis rights. As to an AI output, it can be related either to works created using computer technologies or to non-original objects generated by a computer program, and as I have mentioned before, the criterion for such a division is originality. Let's go on and let's now focus on the first requirement for non-original computer-generated objects. As I have mentioned before, from the legal definition we can conclude that there are two requirements for non-original computer-generated objects. They shall differ from existing similar objects, and they shall be created as the result of functioning of the computer program without direct participation of a natural person in the object creation. We have just addressed the second criterion. Let's now pay attention to the first one. The questions here are: what objects must be used for comparison and what degree of difference is needed? Concerning the first question, the possible answer is works and non-original objects generated by a computer program. It means if an object is just a copy of another object or a work, it cannot be protected at all. In other words, the legislation instead of originality establishes novelty as a requirement for non-original computer-generated objects. Concerning the second question, what degree of difference is needed? The possible answer is minor difference test. It means that if an object differs from others, even in minor details, this is enough in order to satisfy the second criterion. However, difference only in minor details can raise a question of legal basis for using data for training AI or prompt submission. As I have mentioned before, there are no exceptions or limitations in the Ukrainian copyright legislation concerning using data for training AI or prompt submission. Even more, the legislation is quite clear in establishing the necessity of observation of rights, intellectual property rights, or sui generis rights to works or objects used for the generation of the new non-original object as a condition of obtaining the sui generis rights to the new non-original object. It means that in case when a minor difference is the result of illegal use of data, the condition of protection was not met. Another issue was being mentioned in relation to non-original computer-generated objects concerns a list of objects which cannot be protected by exclusive rights. The Article 8 of the Law of Ukraine on Copyright and Related Rights contains a list of objects that are not protected by copyright law. Reporting news or other facts that are in the nature of ordinary press information, expressions of folk art, folklore, acts of state authorities, etc. However, there are no rules for non-original computer-generated objects. The matter is that the legislation regulates relations in the field of non-original computer-generated objects mostly within the Article 33 of the Law of Ukraine on Copyright and Related Rights, and does not pay attention to some other issues regulated by other articles which still may be important in the field of non-original computer-generated objects. As a result, literally, we can talk about exclusive rights to vehicle shuttles, for example, if they are computer-generated. Let's remind that sui generis rights are equaled with economic rights to works with shorter period of protection, and it means that sui generis rights include exclusive rights. So we can have exclusive rights to computer-generated vehicle shuttles, to computer-generated reporting news, etc. However, these objects cannot be protected by any exclusive rights. Probably this is a matter of legislative technique, and this matter can be solved by adding a section to the Article 33 of the Law of Ukraine on Copyright and Related Rights, establishing that sui generis rights shall not arise to objects which are not protected according to the Article 8 of the Law of Ukraine on Copyright and Related Rights. Let's go on and let's now focus on the question: who is the holder of sui generis rights to non-original computer-generated objects? If one tries to sort the answer for this question in the legislation, it is possible to find the following provisions. Sui generis rights to non-original objects generated by a computer program belong to persons to whom economic rights belong or who have licensing rights to a computer program, authors of such a program, their heirs, persons who were granted with economic rights to a computer program by the authors of their heirs, or legitimate users of a computer program. A contract may determine the conditions for the ownership of sui generis rights. Such provisions are not clear and may cause different interpretation in practice, especially in cases of lack of private regulation. To solve the issue, we need to improve the legislation and to establish clearly who is the owner of sui generis rights. In this context, it is worth mentioning that in any case, the owner of rights should be a person, not AI system itself. Although granting AI with electronic personality status is discussed in a doctrine, at least from the lens of copyright law, the situation can and should be solved within the existing order. For example, in the UK, the person by whom the arrangements necessary for the creation of the work are undertaken shall be considered an author. Such an approach is flexible enough in order to be applied either to a programmer or a user, depending on a particular case. Concerning this approach implementation in the Ukrainian legislation, it is worth mentioning that although Ukrainian legislative technique knows some flexible constructions, usually more certainty is required. To establish clear provisions answering the question of who is the holder of sui generis rights, we should take into account that non-original objects include not only objects generated fully automatically, which is a matter of the future, but also, and first of all, objects which do not express creative decisions of a person using a computer program. From this perspective, a hierarchy of owners of sui generis rights should be aimed at protection of rights of a user, who is a person who although does not make creative decisions but still participates in the generation process. For example, inputs quantitative parameters of an object, or provides the general prompt, etc., and thus plays a role, even up to a minimum, in the result obtaining. Taking these considerations into account, the relevant provision can be changed and replaced by the following. Sui generis rights shall belong to a legitimate computer program user if otherwise is not provided by a contract or law. Contractual exception will allow a programmer to keep sui generis rights. This is especially important in cases when a computer program provides minor opportunities for a user to influence the output, and when there is a risk of generation of the same object twice. However, the general presumption that a user is the holder of rights will protect him as a party who usually does not participate in drafting contractual rules. It is worth mentioning that economic rights to works and sui generis rights are transferable, and therefore we need to Investigate contractor rules in order to understand who is the holder of these rights. However, as to the moral rights to works, of course they can belong only to authors. Let's now look at some examples of how economic rights or sui generis rights can be distributed in practice. According to the terms of service of DPI, you, user, may provide input to the services input and receive output from the services based on the input-output. Input and output are collectively referred to as content. You own all right, title, and interest in and to the content. We may use content in a number of ways, including to provide, maintain, develop, and improve our services, comply with applicable law, enforce our terms and policies, and keep our services safe. These provisions give us an understanding that the holder of rights is the user. However, the platform owner can use the outputs for special purposes listed in the terms. The similar approach is used by OpenAI. Do you remember a 4-line poem about love generated by ChatGPT on my request? Let's now look at who is the holder of rights, sui generis rights according to the Ukrainian legislation, to this output. The terms of use of OpenAI establishes as between you, user, and OpenAI, and to the extent permitted by applicable law, you, A, retain your ownership rights in input, and B, own the output. We hereby assign to you all our right, title, and interest, if any, in and to output. Due to the nature of our services and artificial intelligence generally, output may not be unique and other users may receive similar output from our services. Our assignment above does not extend to other users' output or any third-party output. We may use the content to provide, maintain, develop, and improve our services, comply with applicable law, enforce our terms and policies, and keep our services safe. If you do not want us to use your content to train our models, you can opt out by following the special instructions. These rules give us an idea that there is the presumption that a user is the holder of rights. However, this assignment does not extend to other users' output or any third-party output. Also, a platform owner may use the content in different ways. However, if the user does not want the platform owner to use the content, the user can opt out and prohibit such usage. Another approach is used by AVA platform, which is used for generation of music. According to this approach, there is a dependency between a user's plan and rights distribution rules. For example, under a free plan, the copyright of the tracks you create is owned by AVA. A user may use a track with non-commercial purposes only, indicating that soundtrack composed by AVA, artificial intelligence virtual artist. Although the term of copyright here is controversial because if we are talking, for example, about non-original objects, in Ukraine they are protected with sui generis rights, the general understanding of this rule gives us an idea that the holder of rights is a platform owner, and a user may just use a track with non-commercial purposes, and what is also important, a user should give credit to AVA. Under standard plan, a user can use the tracks for monetized content only on YouTube, Tweet, TikTok, and Instagram. The copyright is owned by AVA. You do not need to give credit to AVA when using the track. Once again, the term copyright here is controversial, but the general idea that the owner of rights is still the owner of a platform. However, a user can use the tracks with non-commercial purposes and with commercial purposes, but only on certain platforms, and the user is not obliged to give credit to AVA. Finally, under a prop plan, the copyright of the tracks is owned by a user. Another issue was being mentioned in relation to the holder of sui generis rights concerns non-original computer-generated objects generated for hire and commissioned non-original computer-generated objects. The matter is that we have special rules concerning economic rights distribution to works made for hire, and commissioned works. Let's look at these rules. According to the Article 14.2 of the Law of Ukraine on Copyright and Related Rights, economic rights to a work for hire shall be transferred to the employer from the moment of the work for hire is created in its entirety, unless otherwise provided by this law, an employment agreement, contract, or other agreement on economic rights to a work for hire concluded between the employee also and the employer. Here we have the general presumption that the holder of rights is the employer, not the employee. According to the Article 15 of the Law of Ukraine on Copyright and Related Rights, economic rights to a commissioned work shall be transferred to a person who ordered the work from the moment of the work is created in its entirety, unless otherwise provided by the order agreement. Economic rights to a commissioned work for fine art, except for a work specially created as an element of a computer program, shall belong to its author, unless otherwise provided by agreement or law. Here we have the general presumption that in case of a commissioned work, except of works of fine art, the holder of rights is the person who ordered the work. However, we don't have special rules for generated objects. Along with that, non-original computer-generated objects can also be generated for hire and can also be commissioned ones. Therefore, we need to fill the gap and to extend the relevant provisions concerning economic rights distribution to cases of non-original computer-generated objects generated for hire and commissioned non-original computer-generated objects. This can be done by adding sections to the Article 33 of the Law of Ukraine on Copyright and Related Rights, establishing that sui generis rights to non-original objects generated by a computer program in cases of object generation for hire shall belong to persons determined as owners of economic intellectual property rights according to the Article 14 of the Law of Ukraine on Copyright and Related Rights. Sui generis rights to commissioned non-original objects generated by a computer program shall belong to persons determined as owners of economic intellectual property rights according to the Article 15 of the Law of Ukraine on Copyright and Related Rights. Let's sum up. The Law of Ukraine on Copyright and Related Rights of 2022 is the first attempt in the Ukrainian legislation to regulate relations in the field of non-original computer-generated objects. Article 33 of the Law of Ukraine on Copyright and Related Rights divides objects into two categories: works created with using computer technologies, which are under general copyright law regime protection, and non-original objects generated by a computer program. The legislation is quite accurate in using the terms of objects and works here. When it speaks about non-original objects, it calls them objects. When it deals with original works, it refers to them as works. Concerning non-original computer-generated objects, they shall satisfy two requirements. First, they must be created without direct participation of a natural person in the object creation, which means participation without creative decisions expressed in the output. And second, they must differ from existing similar objects, which means that they must be different from both works and other non-original computer-generated objects, provided that there were no infringements of rights to objects used for the new object generation. Positively estimating the legislative novelty and the general approach used to computer-generated objects, it is worth mentioning that there are still issues which require further legislative improvement. For example, sui generis rights should not arise to objects which are not protected according to the Article 8 of the Law of Ukraine on Copyright and Related Rights, such as vehicles, schedules, reporting news, etc. Also, we need clear understanding of who is the holder of sui generis rights. From my perspective, sui generis rights should belong to a legitimate computer program user if otherwise is not provided by a contract or law. Finally, we need to fill the gap and to extend the provisions concerning rights distribution, economic rights distributions, to works made for hire and commissioned works, to cases of non-original computer-generated objects generated for hire and commissioned non-original computer-generated objects. I thank you very much for your attention. This presentation was based on my publication and you can see the reference here. If you have any questions or if you would like to share your feedback, I will be more than glad to receive your emails. Once again, thank you very much and please do not hesitate to contact me.